Hi there. Today we're talking about how you can win maximum compensation in your lawsuit. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law. I help injured people get the compensation they deserve for their injuries. So today, this is a good topic in terms of getting compensation that you deserve. And we're going to go through what is involved in that and how you can maximize your potential settlement in your lawsuit. So first of all, I want to go through the settlement process to give a bit of an overview. A lot of people wonder about the steps involved in reaching a settlement, not just the final amount, so the steps that it takes to get there. You'll often hear lawyers talking about big settlements like getting a client $100,000 or settling a case for $1 million, but you might be wondering how we get there. You might be wondering what the initial demand was and how many negotiations back and forth took place, so let's break this down. In terms of small case settlements, the smaller the case, like a soft tissue injury where the client gets medical care but then recovers within a few months, we handle settlements in a very straightforward manner. So here's the process that we go through. First of all, we do gather medical records. Once the client finishes treatment or has gone and seen the doctor a few times, then we will request all of their medical records. And this is the supporting evidence that we use in the next step when we draft the settlement letter. Then the next step that we would do is draft an offer letter or a demand letter where we set out what we are looking for in terms of a settlement. This is comparing other cases to yours to see what the outcome was in terms of general damages, and then doing a calculation for any housekeeping losses or loss of income. Then we would send out the initial demand letter, and if it's a fairly small and straightforward case, the initial demand lays out everything that we're looking for and send it out to the property owner or whoever the defendant is. Usually after that, we would start with negotiations based on the settlement offer letter if they're willing to engage in negotiation. Usually it's the insurance adjuster who would respond to the letter and they would give an offer in response to that initial demand. So then usually there's some back and forth and sometimes the case can settle. Otherwise, you might look at filing a claim in small claims or under the Simplified Procedure in Ontario, which is for claims under $200,000 in 2024. For smaller cases, going to trial might not be worth it because of the costs and the risk involved. So it really depends on the severity of the injury and what kind of damages you might be looking at, if it's worth it to file a claim and bring it all the way through to trial if necessary. In looking at more serious cases, though, for more serious cases like those involving a broken bone or a spinal fusion and larger insurance policies that are responding, the process is more complex. So the process in these larger cases is to ideally complete your medical treatment so that we know how your injuries have healed and so that your injuries have progressed to the best point that they will progress to, because then you know the full extent of your damages and your losses once your injuries have plateaued. The next step is to look at potentially a settlement letter to give the insurance company an initial option about settling. Usually, though, the insurance adjuster may not have that kind of authority to settle a large claim. So usually at that point, we would file a lawsuit so that the lawyer can be appointed for the defendant and then potentially look at negotiating before moving ahead with the defense and with the discoveries. But usually we will proceed to discoveries, especially on a larger claim. The defendant will want to know what is going on with the injuries and look at the situation that led to the injuries. So once those discoveries are done, that's the time when the insurance company has a better sense of the case against it and is more likely to settle. In terms of putting pressure on the insurance company, it is usually a good idea to offer to settle fairly early. Then, if there is no resolution, those offers to settle after trial can be brought up by your lawyer and can be pointed to as how you were acting in a reasonable way and trying to resolve the file, where the insurance company was not acting reasonably and ignored your settlement offer. So the impact of settlement letters and offers to settle can be significant at the end of the file. The goal is to ensure a fair settlement for the client and without unnecessarily prolonging the matter. So it is a good idea to put these settlement offers forward, at least to show in the file that you have been reasonable in trying to settle the matter from close to the beginning. And most files do settle, but if the insurance company or defense counsel is unreasonable about it and you have to go to trial, then at least you have in your file evidence that you did try to settle earlier. If you have any other questions or anything comes up for you during this video, please leave me a comment below and I would be happy to address it in another video. Please like this video and subscribe if it's been helpful to you, and I'll see you in my next one.